This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to tell a Who's on First story, where an insurer was obligated to and filed an interpleader to allow claims payment to proper competing claims against the insurance funds that a court ordered it to pay. In an interpleader action arising out of a jury trial in Hanover American Insurance versus Tattooed Millionaire Entertainment, a Western District of Tennessee decision in 2016 called Hanover I, a jury trial was held on insurance claims submitted to Hanover by the defendants in this case, in connection with a 2015 arson fire and alleged theft at the House of Blues recording studio located in Memphis, Tennessee. In Hanover American versus Tattooed Millionaire Entertainment, another case, Hanover II, filed in the USDC for Western District of Tennessee on April 4, 2024, the USDC distributed the available funds deposited by the Hanover. Now, first, Hanover, in its interpleader, also sought declaratory relief, asking that none of the funds be paid out because of public policy, and clearly public policy can ban a payment. However, the Hanover I jury had held that Christopher C. Brown and Tattooed Millionaire Entertainment were indistinguishable, that Brown and TME made material misrepresentations with the intent to deceive and committed unlawful insurance acts during the claims process, and thus Hanover was entitled to recover the advance payments it had made to Brown and TME. And 3, the Hanover jury also held that Falls did not make material misrepresentations or commit unlawful insurance acts, and thus awarded him the maximum amount recoverable under his policy, $2.5 million in business personal property and an additional $250,000 in business income. After the jury trial concluded, the trial court granted Hanover's Rule 50B motion for judgment notwithstanding the verdict and entered an amended judgment denying Falls recovery. The Sixth Circuit, however, reversed the post-trial ruling and remanded with instructions to reinstate the jury verdict to Falls, which the USDC did. In the current action, Hanover filed its complaint for interpleader and declaratory relief. Hanover claimed that the $2.5 million BPP insurance awarded to Falls is subject to multiple competing claims. Hanover's declaratory relief portion of the complaint sought declaration that the $2.5 million BPP award is null and void as a matter of Tennessee public policy. It also pleaded in the alternative that the court must resolve the various competing claims to the BPP insurance proceeds and declare to whom and in what amount those funds should be paid. Therefore, not an Abbott and Costello routine, but a legal determination of who was on first to get the money. Prior to the trial, the parties stipulated to the following facts during a pretrial conference. John Falls leased Studio B at the former House of Blues studio located on Rainier Street in Memphis, Tennessee, and the equipment therein from Christopher Brown, who owned TME. Falls obtained insurance from Hanover that included $2.5 million in coverage for BPP and $500,000 in coverage for business interruption. Brown TME had a separate policy that covered the structure of the studio building. On November 5, 2015, an arson fire occurred at the House of Blues recording studio in Memphis, causing substantial damage to the building and to the business personal property therein. The evidence presented at the trial of the original action, Hanover I, established that Brown TME falsified documents and submitted fake invoices, phony receipts, and doctored bank account statements in connection with the insurance claim following the fire. Obvious fraud. In the appeal regarding the original action, the Sixth Circuit wrote, quote, "The jury awarded Falls $2.5 million as the amount of insurance he was owed up to his policy limit for business personal property. The payment covers the loss of the gear in Falls' studio. However, Brown is the ultimate owner of the lost gear, on which Falls had a perpetually renewable leasehold." Close quote. The public policy argument, an ancient equity maxim that no one should benefit from his own wrongdoing, does not mean that Falls takes nothing of the $2.5 million award. The court's previous rulings found that several summary judgment motions and held that claim preclusion prevented Hanover from asserting claims or arguments against Falls regarding his interest in the business personal property, but does not prevent Hanover from pursuing claims and arguments that TME Brown. The court also dismissed TME Brown's counterclaim for conversion against Hanover. The key determination the United States District Court found in this case was whether and what type of interest Falls had regarding the business personal property. As the Sixth Circuit already noted, Falls had a property interest in the gear in the form of his leasehold, with unlimited renewal options. Leaseholds have been held to be and are, of course, insurable interests. But Hanover also raised the public policy question because the jury in Hanover I found Brown TME to be interchangeable, and Brown himself admitted to fraud in connection with Studio B regarding Brown TME. Any of the BPP profits would go against long-standing public policy of not benefiting the wrongdoer for his own wrongdoing. Therefore, the court held that Brown was not entitled to any of the proceeds. The court therefore found Hanover is precluded from arguing against Falls' recovery. Falls' lease for Studio B and equipment therein did not terminate with the fire. Loss payable clause modifies the language of the schedule in Falls' insurance contract, requiring Hanover to pay BPP jointly to Falls and Brown TME as interest may require. Falls is entitled to recover $2,066,217.30 for the destroyed and missing business personal property. The decision of the state court action is not binding on the district court. Brown TME are not entitled to recover any part of the BPP, as such recovery would violate long-standing Tennessee public policy, and intervener's claim was moot, given that Brown TME are unable to recover any of the monies. In conclusion, the court ordered that Hanover shall pay John Falls $2,066,217.30 for the BPP. Hanover shall not pay or credit the remaining $433,782.70 to Brown TME, and intervener's claim was dismissed with prejudice. In my opinion, insurance disputes are often difficult to resolve, as established by this case that started almost 10 years ago with a jury verdict a judgment notwithstanding the verdict, an appeal reversing the United States District Court, an interpleader action to determine who was on first and could recover more than the $2 million, who would not recover because of public policy, and whether any competing claims could recover anything, so that Hanover was able to keep $433,782.70 because no one else was entitled to the funds. It took many years to resolve, and we can only hope this is the end of a case where an insurer is required to pay an innocent person when the named insured was found to have committed fraud and an arson for profit scheme. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,750 blog postings. You can also subscribe to the videos on Rumble and on YouTube.com. And if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. And I'd appreciate it if you would please tell your friends and colleagues about this blog and the videos and let them subscribe as well. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication, whose last articles dealt with insurance warranties that are used to control the recovery of insurance proceeds and the presentation of honest and honorable claims. Thank you for your attention.